last name?
Kanhai, K-A-N, page 14.
K-A?
Let me just see, hold on. Yeah, K-A-N-H-A-I, on the bottom of page 14.
Okay, Sunil?
Yeah.
Okay.
God, I represented him like 10 years ago.
Okay, we're on the record.
Oh, I'm sorry.
It's okay.
Your private attorney, Mr. Coffey, is coming up.
Okay, good morning, everybody. You're in first appearance magistrate court. Today you're going to be informed of the charges, and we're going to determine if there's probable cause. By the way, my name is Judge Kim Teresa Malika. I want you to keep in mind that today is not your trial day. Do not talk about the facts of your case. Everything is being recorded. You have a right to remain silent. You also have a right to an attorney. There's a public defender, Mr. Romero, in the courtroom, and in the main jail, and we have Mr. Reedy, who's here in the courtroom with me. If you have a private attorney, please let me know when you step up to the podium. We're going to take a couple cases out of order. First case is Sunil Kanhai. Do you need more time? We can pass it.
No, Judge, that's all right. I'm ready.
Okay. All right. Are you Mr. Sunil Kanhai, sir?
Yes.
Okay, sir. You're charged with aggravated assault with a deadly weapon without intent to kill. Any objection to probable cause?
No, Your Honor, I've had the opportunity to review the PC. For purposes of this hearing, we'll stipulate to probable cause.
Okay, the court does find probable cause. I can tell you, sir, there's going to be no return to Joy's roadie delay. State, you want to be heard with regard to bond?
Your Honor, I'm going to be requesting a $15,000 bond, pretrial release of the GPS monitor. According to the probable cause affidavit, the defendant has threatened the victim in the past. He actually returned to the scene with the knife, and that's pursuant to the victim's version of events, video surveillance that captured the incident, and the defendant's admissions to this offense.
Okay.
Judge, I would just argue if you would consider reducing that by about $5,000 to a $10,000 bond. I don't think he has anything significant, at least not as far as I'm aware, and I do believe my client was injured during this event.
Okay, this is what the court's going to do. What does your client do for a living?
Sunil, what do you do for a living? It's been a little while, Judge.
Sell cars. I'm the owner of SNS Auto Sales.
He sells cars.
Okay, this is what the court's going to do. The court's going to set a $10,000 bond. Sir, you are not to return to Joy's roadie delay. Do you understand that? You're going to maintain 1,000 feet at all times. You're going to be on GPS, open schedule, no firearms or ammunitions. If you possess any, you are to surrender them immediately upon your release to your local police department. Do you understand, sir?
Yes, ma'am.
Okay, thank you very much. Thank you.
Judge. Always a pleasure. Nice seeing you.
Nice to see you. Okay, let's call Mr. Odom's cases. Marcelin DeJust.
Yes.
Good morning, sir. How are you?
I'm okay.
Okay, you have a capious misdemeanor for drinking near a licensed establishment. You are no-show at arraignment. What would you like to do with this case, Mr. Odom?
Judge, if the court would get involved on behalf, George Odom on behalf of Ms. McLawrence, is the court inclined to get involved in this matter?
Sure.
We would ask the court, being that it's 2017, there was a few individuals with Mr. Marcel at the time of the incident. I'd ask the court to consider withholding court costs.
Okay, is that what your client wants to do?
Yes, Your Honor.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth? Do you swear and/or affirm to tell the truth, sir?
Yes.
Okay, is your name Marcelin, Marcelyn? Say your last name.
Dieuste, Dieuste.
Thank you. Put your hand down, sir. It's my understanding you wish to waive your right to a trial.
Thank you.
Do you wish to waive and give up your right to a trial, sir? Do you want to plead no contest today and not have a trial?
Yes.
Okay. Is anyone forcing you to do this?
Yeah, but I always got it wrong. I don't even see the letter to go to court.
Is anyone forcing you to plead no contest today?
No. Yeah, no contest.
Okay, are you under the influence of any drugs, alcohol, or medication?
No.
Ever been treated for a mental illness?
No.
Okay, you want to plead no contest to drinking near a licensed establishment, sir?
Yes.
Okay, the court's gonna accept your plea, find that it's freely and voluntarily entered. The court is gonna withhold adjudication and impose court costs, which I have to by law, of $78. The court's gonna take judicial notice of, time served in the Broward County Jail. And the court's gonna give you 6 months to pay the $78, which is payable by the clerk. You have 30 days to appeal the sentence of the court. If you cannot afford an attorney, sir, one will be appointed. Thank you and good luck to you, okay? You should be released.
Thank you, Your Honor.
Jeffrey, you're welcome. Jeffrey William Lynch.
Again, George Odom standing in on behalf of Mr. McLawrence.
Okay, are you Jeffrey William Lynch, sir?
Yes.
Okay, sir, you have two alcoholic beverage violations, and you have lodging underneath the bridge. What would you like to do with this? He has no show at arraignment for these.
Yeah, Judge, absent potential statute of limitations issues, I think Mr. Lynch still wants to resolve. Two of these are Fort Lauderdale cases, and then one I believe is the city of, I want to say Pompano. But I would ask the court to get involved with the global offer
Sure.
of withhold on one and at least on 1 and 3. I leave it to the court's discretion on 2 and court costs respectively for each count.
Okay, which one is the Pompano one, the lodging underneath the bridge?
Yes, Your Honor, the 2737 MO20A.
Okay. Okay, does your client agree not to return?
Yes, Your Honor. Even though I have not specifically spoken to him about the count 2, but I don't think that's going to be an issue.
Okay, do you agree to that, sir, not to return to the location where you were lodging underneath the bridge?
Yes, ma'am.
Okay, raise your right hand. Do you swear and/or affirm to tell the truth, sir?
Yes, I do.
Okay, is your name Jeffrey William Lynch, Lynch?
That's correct.
It's my understanding you wish to waive your right to an attorney in the 2 alcoholic beverage violations, and you wish to waive your right to an attorney and trial for lodging underneath the bridge. Is that correct?
That's correct.
Is anyone forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Okay, you want to plead no contest to 2 alcoholic beverage violations and lodging underneath the bridge, sir?
Yes, I do.
All right, the court's going to accept your plea, find that's freely and voluntarily given. The court has reviewed the court file and finds probable cause for the plea. You are not to return to the location where it's alleged that you were sleeping under the bridge. The court's going to withhold on each case, impose $78 in each case for court costs. The court will give them 6 months to pay in each one. Court will take judicial notice of the time that he served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck, sir. You're done with these 3 cases. Thank you. Okay, next case is Dearies Quintel Snell. Thank you, madam. Okay, we are here on a capious misdemeanor for a battery, and then you have an out-of-county hold for Volusia County for an organized scheme to defraud for a grand theft. That bond is set for the out-of-county hold in Volusia is set at $25,000. The capious misdemeanor is set at $1,000. Court does find probable cause. Anybody wish to be heard? Let me just see the capious.
This is a court-ordered capious issued by Judge McHugh.
I see that. All right, so
The only thing I would ask is for a no-contact order. The alleged victim's name is Lakeisha Godfrey. And I provided name to the clerk so a no-contact order can be prepared.
okay, there's no contact, direct or indirect, with the alleged victim, Keisha Godfrey. That means no contact in person, no contact indirectly, which means through third parties, no contact through texting, calling. Hold on.
Judge, I believe the alleged victim and Mr. Snell share a child in common. for purposes of arranging child visitation, could they go through a third party? No direct contact, but through a third party.
Sure.
Thank you, Judge.
Okay, that contact also prohibits, sir, no contact through any social media such as Facebook, liking, disliking, commenting, or anything like that. Do you understand, sir?
Yes.
Okay, does anybody want to be heard with regard to the $1,000 bond?
Judge, considering he has, I believe, a holdout of Volusia County, not at this time, Judge.
Okay, and upon your release, sir, if you possess any firearms or ammunition, you're to surrender them to your local police department, okay? Good luck to you, sir. Thank you. Next one's gonna be Brenda Erlin Troches.
Honor, there are other domestics on the docket.
Where do I get these from? They're not in order.
Kadeen Ald is the first domestic on the
Which
docket.
one?
Kadeen Ald.
What page is that?
One.
Page 1, Judge. Miss Auld is here, present at Maine. Miss Auld, come on up.
Out of order. Is there another one? I don't know why they're all out of order, but that's okay. All right, so the next one's gonna be Kadeen Latoya Ald.
Yes,
Good morning,
sure.
ma'am. You're charged with battery, cause bodily harm, domestic violence. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause. Court's gonna order no victim contact, direct or indirect, with the alleged victim with the initials TRH. Direct or indirect means, ma'am, no contact in person, calling, texting, through social media, or through third parties. Do you understand?
Yes, ma'am.
Okay. Case state, wish to be heard?
Yes, Your Honor, the state's requesting $1,500 bond. Ms. Ald, she was arrested for domestic violence assault in 2012 against a different alleged victim. That charge was dropped.
Okay, do you wish to be heard with regard to bond?
I do, Judge. It appears she has no prior criminal record. The defendant in this case refused to provide a sworn statement or allow pictures of his injuries to be taken.
Okay.
Judge, the alleged victim is her boyfriend. They do live separate and apart. I believe the boyfriend lives in Lauderhill. Miss Auld resides in Lauderdale Lake. She resides with her parents. Her mom is right now basically supporting the household as Miss Auld looks for employment. She's, from what she advised me, her mom is like a medical coding specialist, doesn't have a lot of financial resources. So Judge, we'd be asking you to consider on this case a $500 bond on Miss Auld's behalf.
Okay, court's gonna order, no firearms or ammunition, and for Ms. Auld to surrender them, if she possesses any, to her local police department immediately upon her release. Court's gonna do a $500 bond. Thank you.
And Judge, would you sign a photo order as well?
Sure.
Thank you, Judge.
You're welcome. Shabina Denise German,
She's approaching, Judge.
thank you. Mr. Odom, do you have any others? Okay, just hanging. Okay, if they could go outside, please, and talk. Sabrina Denise German.
Yes, Judge.
Okay, ma'am, you're charged with 2 counts, touch or strike battery. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause. Ma'am, I'll tell you to start off with, you are to have no contact, direct or indirect, with the alleged victim in the case with the initials SSC. That means no contact, ma'am, through, in person, telephone, texting, blogging, anything on social media, and through third parties. You understand?
Yes, Your Honor.
Okay, you're also not to possess any firearms or ammunition, and you're to surrender any to your local police department immediately upon your release. Do you understand that as well?
Yes, ma'am.
Okay, Mr. Linder?
Your Honor, based on the allegations and her criminal history, I'm going to be requesting bonds in the amount of $2,000 per count. In 2010, she was arrested for felony battery domestic violence by strangulation against a different woman. That was dropped. 2000, grand theft, a year and a day state prison. 1999, sale delivery of cocaine within 1,000 feet of a school, resisting without violence, 3-year state prison. 1997, felony criminal mischief, violation of probation, delivery of cocaine, 96, possession of cocaine with intent to sell or distribute, 95, with a violation of probation.
Okay, defense?
Judge, Ms. German, she's 41 years old, residing in our community her whole entire life. At this time, she is working, she's self-employed. She cleans for a living, Judge. She gets on an average about $150 per week. From what she advised me, she really has no savings. Unfortunately, she has no family here in the community, Judge, no one that can assist her financially with posting any sort of bond. She lives in a duplex by herself, been there for about 7 years. I believe the alleged victim does reside somewhere else, Judge. So as far as the no contact with the alleged victim, she's going to have no problem abiding by the court's order. We'd be asking you to consider releasing Ms. German on standard pretrial release, Judge. Unfortunately, she can't come up with any sort of monetary bond.
Anything further, State? Okay, court is gonna set her bond at $500 per count. No victim contact, no firearms, surrender to her local police department, GPS level 2. Thank you. And she's to maintain 1,000 feet from the alleged victim's home, work, or school. Thank you. Richard Yapes?
Mr. Yates is here present, Judge. He declined to serve as the public defender.
Okay, Mr. Yapes, the court does find probable cause for 1 count of touch or strike battery, sir. I'm going to tell you at the outset, you're going to have no contact, direct or indirect, with the alleged victim with the initials DDC. That means you cannot have contact in person, via phone, texting, blogging, anything through social media, liking, disliking, or through third parties. Do you understand, sir?
Yes.
You're also, sir, not to possess any firearms or ammunition, and if you do possess any, you're to surrender them immediately upon your release. Do you understand that as well?
Yes, ma'am.
Okay, State, let's talk about bond.
Your Honor, I'm going to be requesting a $10,000 bond, pretrial release with a GPS monitor. I'm also going to be asking for a no contact order with either of the listed children. Your Honor, I'd first note the level of violence alleged in this case. Mr. Yepes allegedly grabbed the victim by her hair while she was in bed and dragged her off the bed onto the floor. He began punching her in the head, kicking her in the torso, and at a later point threw a laundry basket at the victim while their 4-year-old child was holding out, grabbing the victim's leg, striking the 4-year-old with the laundry basket. Your Honor, law enforcement spoke to the 4-year-old and corroborated the victim's version of events. I'd also note in 2011, Mr. Yepes was arrested for aggravated battery against a pregnant victim against the same alleged victim. That charge was dropped.
Okay, Mr. Yapes, your response to bond, sir, they're asking for $10,000 and a GPS monitor, and no victim contact with the minor children. So the court is going to order no contact with the 2 minor children. At this point in time, you can go back before your division judge and ask to have contact via them, unless it's supervised and approved by The family court judge. What's your response to the $10,000 bond, sir? Can you afford $1,000 to pay a bondsman? Put up collateral?
No.
Okay, what can you afford, sir?
1,000. 1,000?
$1,000 cash?
Your Honor,
Yeah.
I just want to know, because the court was looking down, he's looking over to the side and almost asking someone 1,000. And then something was said, and then he turns to the court and says, yeah, 1,000.
Okay, sir, let me ask you this. Do you own a car?
Yes.
What kind of car do you have?
Pickup truck.
What year is it?
2014.
How much money do you have in the bank, sir?
$300.
Do you have friends or family that can help you with the bond?
Yes.
Okay. Okay, how much are you asking for with regard to a bond?
500.
Okay, this is what the court's gonna do. The court's gonna set your bond at $5,000, no victim contact, no contact with the two minor children
Your
unless
Honor,
supervised.
we lost.
Okay, sir, let me start from the top because the camera cut out, okay? $5,000 bond, no victim contact, direct or indirect, with the alleged victim with the initial DDC. That also includes no contact with the two minor children. With regard to the two minor children, unless it's supervised and approved by a family court judge, which I don't know if there's an order or not yet, but this way at least you don't have to go back to the criminal court. You're not to possess any firearms or ammunition and surrender them immediately upon your release. Okay, sir? $5,000 bond. Oh, GPS. And we'll do an open schedule. Thank you,
Your Honor,
sir.
Your Honor, the state would object to an open schedule. Because this is domestic in nature, we would ask that he keep a schedule for monitoring purposes with pretrial release.
What do you do, sir?
I service pools.
Okay, the court's gonna do an open schedule. Maintain 1,000 feet from the alleged victim's residence, work, and school. Okay, sir? Good luck to you. Kenneth Morin, M-O-R-I-N.
He's here, present, Judge, at Maine.
Okay, Mr. Morin, you are charged with 1 count, touch or strike battery. Any objection to probable cause?
No, Your Honor.
Oh, on that last one, was Cephas or anybody,
Yes.
okay. I know on this one it is. Okay, I'm sorry. Any objection to probable cause?
No, Your Honor.
Okay, sorry about that. The court does find probable cause for touch or strike battery, sir. The court is gonna order no contact, direct or indirect, with the alleged victim in the case with the initials CMC. And that means, sir, no contact in person, on the phone, texting, no calling, no contact through third parties, no contact through any social media, liking, disliking something, okay? Or any other type of social media like Facebook and the like. So, let's talk about bond.
Your Honor, Mr. Marin was arrested last year for battery against, domestic violence battery against the same alleged victim. The charge was dropped a month ago. In light of this and the allegations in this case, I'm requesting a $5,000 bond.
Okay, defense?
Judge, in speaking with Mr. Morin, he does not reside with the alleged victim. He resides with his mother, who's residing at home. His mom is retired, so financially right now, she doesn't have much financial resources. From what Mr. Morin advised me, he's unemployed. He was working in construction. Unfortunately, he lost that job. He's 49 years old, been residing in our community for well over 40 years. He's looking forward to his day in court, Judge. At this time, when I asked him how much he can afford, he really doesn't know his mom's financial resources, but it's not much, if at all. Judge, respectfully, I'd be asking you to consider setting a $1,500 bond. Hopefully his mother can come up with the premium with the bondsman, and that's what we'd be asking for at this time, Judge.
What about no contact with the alleged child? There was a 3-year-old son. Who,
Judge, in abundance of caution, I think Mr. Moore is, at this time, he seems very reasonable. At this time, he does not want, to jeopardize anything. So he has no problem with no contact, and we're not gonna ask for any sort of order, through a third-person contact. He just wants to let all the pieces settle and have his day in court, Judge, so.
okay,
at
no
this time-
contact with the minor children.
Okay.
What does your client do for a living?
At this time, like I said, Judge, he's unemployed. He was working construction. He just lost his job. He's looking, and right now his sole financial income, or the person supporting him, is mother, who's retired. So that's why we are asking what we asked as far as $1,500 we feel is reasonable, Judge, for this misdemeanor offense.
Okay, $1,500 bond, no victim contact or any contact, direct or indirect, with the minor children, no firearms, surrender them to your local law enforcement if you do possess any immediately upon your release. GPS level 2. Thank you. Next one is Jose Reyes.
Mr. Reyes will require a
Reyes, I'm
Spanish
sorry.
interpreter, Your Honor. We have one on the way.
Señor,
Okay.
ahorita un intérprete va a venir.
I'm sorry, Miss Patrice, I did not see this here. Brenda Erlin Troches.
Paul Ryan.
Okay, one moment, Ms. Troches. Ma'am, you have a capious misdemeanor for possession of drug paraphernalia. It's an ad charge.
Yes, Your Honor. Ms. Troches has a no bond capias on count 1. We'd just ask the court to leave the $1,000 bond in place at this time.
Okay, so the court will leave a $1,000 bond.
This was issued when she was in custody, right?
Am I
Okay.
allowed to plead out?
You can, ma'am, but because you have a pending felony, the court's not gonna, resolve this case at this point, okay? Good luck to you.
Okay, thank you.
Yes. Hold on, ma'am. Ma'am, come on back.
Yes.
Judge, I'd ask you to set a nominal bond for Ms. Troches so that she still gets credit for time served. If you get released on your own recognizance on this charge, even though it's a misdemeanor, Ms. Troches, you will no longer be getting credit for time served. So I'm gonna ask the court for a $25 bond.
I set it at $1, okay?
$1,
Thank you.
okay. So you can bond out for $1 once you resolve your other case, okay?
Thank you.
All right, good luck.
Darlene Williams, please.
North Broward.
Okay, Darlene Williams. Good morning.
Ms. Williams would
Hi.
like to resolve this if possible, Your Honor.
Okay, Ms. Williams, you are charged with trespass, failure to leave property upon order by owner, state. This is the McDonald's.
Yes, ma'am.
She agreed not to return.
She has told me she will not return.
Did you tell her what might happen if she does return?
I said that the court might be upset with her and she will find herself right back in jail.
States offered me a time served.
Okay, adjudication time served and $293 fine. How much time to pay?
How much time do you need to pay that, Miss Williams? 6 months, 1 year?
1 year.
Okay. And is that what you want to do? Do you want to take adjudication time served on this case? Give up your right to trial?
Yes.
Okay.
All right, thank you. All right, ma'am, raise your right hand. Do you swear and/or affirm to tell the truth?
I do.
Okay, put your hand down. Is your name Darlene Williams, Williams?
Yes, it is.
Okay, it's my understanding you wish to waive your right to a trial, ma'am?
Yes.
Is anyone forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
Not at this time, no.
Ever been
High
treated?
blood pressure meds.
Okay, have you ever been treated for a mental illness?
Clinical depression years ago.
Okay, does that mental illness affect your ability to understand what's going on here today, ma'am?
No.
So you understand everything here today with clarity?
Yes, I do.
You want to plead no contest to trespass for failure to leave property upon order by owner?
Yes, please.
The court's going to accept your plea, find that it's freely and voluntarily entered. The court's going to adjudicate your time served, you impose court costs $293. The court will give you 1 year to pay. You're not to return to McDonald's at 2025 East Atlantic Boulevard in Pompano Beach, Florida. You understand, ma'am?
Yes,
No-
ma'am.
no return?
Yes, Your Honor.
Okay, you have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, ma'am, other than paying the $293. Good luck to you.
Have a good day. Thank you.
You're welcome. TT Olusola. TT Olusola.
Judge, I've been advised she bonded.
Dathamshire Clark.
Paul Run.
Are you Dathamshire Clark?
Yes.
Okay, you'd like to resolve your case today?
Yes.
State?
State's offered be time served.
Adjudication time served, $293 in court costs. How much time to pay?
Your Honor, and also, no return to BJ's Brewhouse Plaza.
I'm sorry, BJ's
Brewhouse Plaza
Brew House Plaza.
at 12100 Pines Boulevard.
Hold on, one. I'm writing it down.
12100 Pines Boulevard.
Is that in Pembroke Pines?
Yes, ma'am.
Okay, raise your right hand. Do you swear and or affirm to tell the truth? Raise your right hand, ma'am. Do you want to, ma'am? Do you swear and or affirm to tell the truth? Okay. Where is Dathamshire Clark? I'm hearing someone else's voice. I don't know what's going on here. Okay. Can somebody mute the mic at North Broward for me? Okay, do you swear and or affirm to tell the truth, Ms. Clark?
Yes.
Okay, put your hand down. State your first and last name. Okay, the court's not gonna take her plea. Let's transfer her. Do you think it's appropriate to learn a Ren?
I don't have an objection.
Pardon?
I don't have an objection.
Court's gonna leave her $25 bond in place. Ma'am, we're gonna send you to Judge Lerner Wren's court. She'll be better able to assist you, okay?
That's fine, Judge.
Okay, $25 bonds being kept in place. Thank you. Jennifer St. Jean.
Yes, ma'am. Yes, ma'am. Sorry.
Where are you, North Broward?
Yes, ma'am.
Okay, you are charged with battery on a person 65 years of age or older. Any objection to probable cause?
No, Your Honor.
Court does order no victim contact, direct or indirect, with the alleged victim with the initials DS. That means no contact in person through third parties, no calling on the phone, texting, anything on social media whatsoever, liking or disliking. You're not to possess any firearms, ammunition, or weapons. If you possess any, you are to surrender them immediately upon your release to your local police department. State?
Your Honor, I'm going to be requesting a $3,500 bond based on the allegations in Ms. St. Jean's criminal history, which includes 2017 theft and drug paraphernalia, 2015 possession of cocaine with a violation of probation, 2015 possession of cocaine oxycodone with a violation of probation, 2013 possession of cocaine paraphernalia, 2012 possession of cocaine.
Okay, defense?
Your Honor, I don't think Miss St. Jean's going to be able to make that kind of a bond. She has been a resident here of South Florida for the last 8 years. She has family here, including her brother and her mother. She's given me her mother's name and number. She also has a boyfriend here, and she's asked me to call him as well. But they don't know, she doesn't know if they're going to be able to come up with that high a bond. I'd ask the court for a $1,000 bond. I think that's something that between the boyfriend and the mother and the brother, they may be able to come up with to get her out.
Does she live at 4441 Southwest 27 Terrace?
Miss St. Jean?
Or is it the 803?
Ma'am, that is my residence, and that is where the man actually attacked me.
Okay.
So, I'm gonna go stay with, my brother on Monroe until further notice, because that 4441 is where the incident occurred. I was going to get my belongings when, this man actually attacked me, and I called the
Okay,
police.
don't talk about the facts of your case, ma'am.
Okay, yes, sir, yes, ma'am.
Court's gonna do a $1,000 bond, no victim contact, no firearms, surrender to local law enforcement, standard pretrial release. Thank you, ma'am. Good luck to you.
Thank you, ma'am, thank you.
Elizabeth Roquetta?
24 hours.
Hello, how are you?
Hi, how are you? Good morning.
Fine, thank you. Ma'am, you're charged with criminal mischief over $1,000. Any objection to probable cause?
No, Judge, no objection to probable cause.
Okay, ma'am, the court's gonna say at the outset, there's gonna be no contact with Rogers Electric or any of its property, namely its, vehicles.
Okay.
And right, state, bond set at does anybody wish to be heard with regard to the $500 bond?
Yes, Your Honor, I'm going to be requesting pretrial release from Ms. Roquetta. She's indicated to me that she's been a resident of South Florida for all of her life. She does have her family here, including her mother. She's been employed at the same job as a tattoo artist for the last 8 years. She's studying humanities at FIU. She's provided me with the name and number of her mother to call. She indicated to me that she's never had any prior contact with the criminal justice system and that I think she would be a good candidate for pretrial release. She doesn't know if she's going to be able to come up with any kind of monetary bond. She doesn't have any money herself.
I'm a bit concerned hearing that because in 2013 in Dade County, she had a theft. And in 2013 in Dade, she was convicted of possession of controlled substance by fraud.
Do you have anything showing she failed to appear?
Your Honor, I have no prior failures to appear, but I just what appears, and she's providing Ms. Aridi with false information to provide to the court.
Negative. I now have no priors in Bard County. I have no priors in Bard County.
Maybe I wasn't specific enough with her when I asked her about her prior record, Judge.
Okay, no contact with Roger Electric Vehicles and standard pretrial release. You're gonna have to report, ma'am, by tomorrow, 3 p.m. You'll probably get out today if you don't have anything else pending. And the deputy at North Broward will give you a map, okay? Thank you, ma'am.
All right, thank you.
Sure. Hello, how are you? Okay, ma'am, we're gonna call one person at a turn, okay? Jose Reyes? Does anybody know where Jose Reyes is or Reyes?
Yes. Main jail.
He's here, President Maine.
Okay, Mr. Interpreter, if you could raise your right hand, do you swear and/or affirm to translate from Spanish to English, English to Spanish to the best of your ability?
I do. Esteban Rojas.
Okay, can you spell your last name for the court?
Rojas.
Okay, are you Jose Reyes?
Usted es José Reyes.
Yo soy José Reyes.
I am José Reyes, Your Honor.
You are charged with one count of domestic violence injunction,
A usted se le,
willful violation.
se le acusa de violar de manera dolosa un interdicto de protección por violencia doméstica.
Any objection to probable cause?
¿Alguna objeción a los indicios probables de delito?
No, Your Honor, based on his statement, but he does seem to indicate that his concern was for his son. If true, I think that's quite a mitigating circumstance.
No, Su Señoría. Basado en su declaración, no objetaríamos los indicios probables. Sin embargo, él sí manifiesta que su preocupación era por su hijo y eso sería un atenuante de peso.
Also, the victim refused to give a sworn statement about the incident.
Asimismo, la víctima se rehusó a dar una declaración jurada sobre el incidente.
Okay, the court's gonna order no victim contact with the alleged victim with the initials RH.
La Corte ordena que se abstenga de contacto alguno con la supuesta víctima cuyas iniciales son RH.
He is allowed, though, to have contact with his son.
Sin embargo, sí se le permitirá tener contacto con su hijo.
And by saying that, I mean I'm not ordering no contact with the son.
Y cuando digo eso me refiero a que no estoy ordenando que se abstenga de tener contacto con el hijo.
If there's some other order, he has to follow that order
Si hay alguna otra orden vigente, tiene que seguir esa orden
with regard to contact of his son.
en lo que respecta al contacto con su hijo.
Okay, state.
Your Honor,
Fiscalía,
I'm going to be requesting a $2,500 bond.
Su Señoría, vamos a solicitar que se imponga una fianza de $2,500.
You know, as Mr. Reedy said, we don't know if his claims are true.
Como dijo el señor Reedy, nosotros no sabemos si las declaraciones del sujeto son verídicas.
What we do know is that there was allegations of violence in 2016
Lo que sí sabemos es que se alegó violencia en el 2016
that a circuit court judge
y un juez de circuito
found were legally sufficient to order an order of protection.
consideró que esos alegatos constituían una base suficiente como para ordenar un interdicto de protección.
And it has to be followed, no matter
Y
what.
debe seguirse sin importar cualquier otra circunstancia.
Okay, defense.
So,
Judge, just for clarification, I just wanted to know, what is the state recommending for a bond on this matter?
Su Señoría, solo para aclarar, ¿qué es lo que está recomendando la Fiscalía a modo de fianza?
$2,500.
$2,500.
And Judge, may I inquire if there was any other prior violations of injunction? Because Mr. Lunder said it was a couple of years since these injunctions been in effect.
Su Señoría, ¿puedo indagar si hubo alguna otra violación de un interdicto? Porque tengo entendido que el interdicto en cuestión se interpuso hace un par de años ya.
I can assure the court, if there were prior violations, I would have advised.
Puedo asegurarle a la Corte que si hubiera habido violaciones previas, ya se lo hubiera informado.
Okay, go ahead, Mr. Romero.
Judge, having said that, I'd ask you then to set a bond of $300.
Señora juez, entonces solicitaría que se imponga una fianza de $300.
This is why.
Por la siguiente razón.
Mr. Reyes is 50 years old. He's been living here for about 18 years now in South Florida.
El señor Reyes tiene 50 años, ha vivido en el sur de Florida durante unos 18 años ya.
He's working for a company. It's a roofing company, Judge. He's been employed with them for about 2 months now.
Está trabajando para una compañía que restaura y repara techos. Ha estado trabajando para esa compañía durante 2 meses ya.
When he works, Judge, he gets approximately $100 per day.
Cuando trabaja, su señoría recibe aproximadamente $100 por día.
My understanding is that injunction's been in place for a couple of years. He used to reside with his wife in Oakland Park. They shared that apartment. I believe the rent was around $1,000 per month.
Tengo entendido que hasta hace un par de años vivía con su esposa en un apartamento en Oakland Park, cuyo alquiler era aproximadamente $1,000.
Since he left that place, in order to follow the rules of the injunction, Judge, he now resides in Oakland Park with a roommate, and he shares his expenses, and that expense is about $400 per month.
Desde que tuvo que abandonar el apartamento en Oakland Park para cumplir con el interdicto de protección, vive con un compañero de apartamento en otro apartamento en Oakland Park y sus gastos ascienden a unos $400 por mes.
Besides his own expenses, Judge, also he helps take care of his son financially.
Y aparte de los gastos suyos propios, él también ayuda con la manutención económica de su hijo.
Judge, so from my understanding is this injunction's been in place many years. He's followed it, and so that would lead me to believe it was probably an important reason, the allegation as far as why he violated this injunction. I'd ask you to take into account my colleague's argument for mitigation circumstances, Judge.
Según tengo entendido, señora juez, este interdicto tiene bastante tiempo de haber sido interpuesto y siempre lo respetó, lo cual significa que si lo violó debe haber sido por una razón de bastante peso. Entonces me adheriría al argumento presentado por mi colega en cuanto a las atenuantes.
Judge, from what he advised me, he has resources in the amount of $322.
Según me informa el sujeto, tiene recursos que ascienden a $322.
And that is why we feel in this situation $300 would be a reasonable bond on Mr. Reyes' behalf.
Y por eso consideramos que en esta situación $300 sería un monto razonable para el señor Reyes.
Okay, $1,500 bond, no victim contact with the alleged victim, RH, no firearms, surrendered to the local police department immediately upon his release.
Bien, se impone una fianza de $1,500. No deberá tener contacto alguno con la supuesta víctima. Si posee armas de fuego, deberá entregárselas a su departamento de policía local, tan pronto como sea excarcelado.
GPS open schedule,
Se le pondrá un monitor GPS con horario abierto
maintain 1,000 feet from the victim's home.
y deberá mantenerse alejado a una distancia de 1,000 pies de la casa de la víctima.
And Judge, would you sign a phone order?
Señora juez, ¿firmaría una
Yes.
orden dándole acceso a su teléfono? Sí.
Yes.
Thank you, Judge.
Gracias,
welcome.
señora juez.
Okay, can you make an announcement? See if we
¿Alguna
have
otra
anyone
persona
else?
necesita interpretación en español?
Paul
Judge,
Ryan.
there's more people here at Maine when you have a chance.
All right, let me get the name and then I'll go to Paul Ryan. What's your names? Tell me
The
the
first
names
gentleman
and
is
page
the
numbers.
Emiliano Martinez Villalobos. Rodriguez? Mauricio Rodriguez, Judge.
Okay,
I'm trying to locate him
I
right now.
got it. And where's the next one?
Roberto Diaz, Judge.
What page is that?
16, Judge.
What page was Rodriguez?
That's who I'm right now looking for, Judge.
Roberto Diaz?
It's Haberto,
Yes.
Okay.
H.
Okay, let me go to Paul Ryan. I'll be right back. Okay, Paul Ryan, who do we have for a Spanish interpreter?
Page 12, we have Mr. Villalobos Martinez.
Okay, sir, are you Emiliano Villalobos Martinez?
Señor, ¿es usted Emiliano Villalobos Martínez?
Sí.
Yes.
Okay, you have an ad charge for a battery.
Usted tiene un cargo adicional por lesiones.
Bond is set at $1,000.
Se le impone una fianza de $1,000.
You have a status hearing before your division judge,
Tiene una vista ante el juez de su división,
Judge Michael Rothschild,
el juez Michael Rothschild.
tomorrow
Mañana,
March 14th
el 14 de marzo,
at 9
a
a.m.
las 9 de la mañana.
Anybody wish to be heard with regard to bond?
¿Alguna persona quiere ser escuchada con respecto a la fianza?
Your Honor, Mr. Villalobos Martinez has a current bond of $30,000 on counts 1 and 2, $15,000 each.
Su
Sorry,
señoría,
say that
para
again?
He has a count 1 and count 2 each have a $15,000 bond.
Okay.
I'd ask you to leave this bond in place so he can go in front of his judge tomorrow.
Su señoría, el señor Villalobos Martínez, tiene una fianza actualmente de $30,000, $15,000 para cada uno de los cargos. Solicitaría que deje incólume esa fianza para la vista que tiene que celebrar ante el juez de su decisión mañana.
Okay, court is gonna change the bond to $999.
La corte va a modificar la fianza a $999.
Thank you.
Gracias.
Gracias.
Thank you,
Thank
sir.
you.
Mauricio Rodriguez?
Your Honor, Mr. Rodriguez has family here.
Su señoría, el señor Rodríguez tiene familia acá.
They've indicated to me that they have already posted his bond.
Me indican que ya pagaron su fianza.
That's what Mr. Rodriguez advised me, Judge, so.
Eso es lo que me acaba de informar el señor Rodríguez, señora juez.
Okay, the court does find probable cause.
La corte considera que existen indicios probables de delito.
The court is gonna order no return to the gap.
Se le ordena no regresar al local de GAP,
At
ubicado
12801
en la 1281
West Sunrise Boulevard,
West Sunrise Boulevard
Sunrise, Florida.
en Sunrise, Florida.
Okay, and your name is?
Su nombre es,
Ma'am, yes.
el nombre de la señora es Ana.
Can you state your last name and spell it?
¿Puede decir su apellido y deletréelo, por favor?
SCARNCI. Scarinci.
Okay, and your relation to Mr. Rodriguez?
Su parentesco con el señor Rodríguez es
This is my husband.
mi marido.
Okay, so the bond's been posted. Good luck to you, sir.
Bien, ya se ha
Was
pagado
that
la
confirmed,
fianza.
Judge?
Buena suerte, señor. Está confirmado,
Sheila,
señora
do you
juez.
know if they posted the bond? Hold on, have them wait a moment.
Un momento, por favor.
Okay.
Ya tiene el recibo en
Wife
su
has
celular.
the receipt. It's
Ella ya
$25,
tiene el recibo.
Mr. Romero, okay? All right, next one is Roberto Diaz.
Huberto Díaz.
Mr. Diaz is here present. Come on up, sir.
Señor
Thank
Díaz
you,
está
ma'am.
acá.
Good luck to you.
Gracias, señora. Buena suerte.
Okay, are you Mr. Roberto Diaz, sir?
¿Usted es Huberto Díaz? ¿O Eberto Díaz? Yes.
You are charged with 7 counts of burglary, unoccupied conveyance, unarmed.
A usted se le acusa de 7 cargos de hurto en un vehículo desocupado sin arma.
These are add charges.
Estas son cargos agregados.
Count 8 is an immigration hold,
El cargo 8 es una orden de detención migratoria
where you're going to be held no bond.
y para esa no hay fianza.
Neither one of us has counts 1 through 4.
Señora juez, un momento, ninguno de los dos fiscales tenemos los cargos del 1 al 4. El señor Díaz tiene...
That's what I have.
El
1
señor
through
Díaz
7 is burglary of a conveyance.
tiene cargos agregados. Sin
Okay,
embargo,
I have 1 through 7 on my sheet. I only have the piece, well, 5, 6, 7 is on my sheet.
el señor Díaz,
Southwind irrigation. Warren Duke. I don't know, I have what I have here, so.
We have the same thing, Your Honor. Neither you or I have the booking
El señor Díaz inicialmente tiene cargos agregados, sin embargo, inicialmente fue traído por los cargos del 1 al 4. La jueza indica que ella tiene los cargos 1 al 7, sin embargo, solo tiene indicios probables de delito para 5, 6 y 7.
Okay, so let's just reset this for this afternoon.
Vamos a aplazar este caso para esta tarde.
Oh, you are?
Estoy
Okay.
haciendo una copia, su señoría.
So, any objection to probable cause?
¿Alguna objeción en cuanto a los
Anything,
indicios
Mr.
probables? Señor
Not
Reed?
as to 5, 6, and 7.
No con respecto a las 5, 6 y 7.
Okay, you know what? Mr. Reedy needs to read it. I need to read it. We're resetting this for
El
this
señor
afternoon.
Reedy tiene que leer el documento, yo también. Vamos a aplazar esta audiencia para esta tarde.
For the PM docket. Thank you.
Gracias.
Judge.
Okay, there you go, Madam Clerk, if you can attach this. All right, anybody else need a Spanish interpreter?
¿Alguna otra persona necesita intérprete?
No one else at Main, Judge.
Nadie más
Okay, let
acá,
me
señora
check.
juez.
Anybody at North Broward need a Spanish interpreter? Is there any deputy there?
No, Your Honor.
Thank you. Conti need a Spanish interpreter?
No, ma'am.
Okay, and Paul Ryan, anybody need a Spanish interpreter? No, obviously they're gone. Okay, next person, continuing with our docket. Thank you so much, sir. Latasha Denise Smith.
Yes.
Okay, thank you for your patience, ma'am. You have a charge of grand theft auto, which bond is set at $1,000. Count 2 is a violation of probation. You have a $5,000 bond set in that case. You do have a hearing on Thursday before Judge Michael Rothschild at 8:30 a.m. on the violation of probation. Anybody wish to be heard with regard to probable cause or bond?
I explained to Ms. Smith that there was very little the court could do as to the $5,000 bond on count 2. I think she needs to go in front of Judge Rothschild on Thursday and try and see what can be worked out at that time.
Okay. All right, ma'am, in the meantime, there's gonna be no contact, direct or indirect, with the alleged victim in this case. That means in person. via te- Well, you're not gonna have contact right now.
Okay.
Unless state you wanna agree to contact.
Judge.
No,
I
you,
mean,
I don't want to agree to contact Judge.
this was something he did he was angry at other
okay, ma'am,
people,
don't
so-
talk about the facts of your
Don't-
case.
yeah.
As far as Lonnie James Moore, ma'am, you're not to have any contact, direct or indirect. That means no contact in person, no contact, via telephone, texting, through social media, liking or disliking anything, or any contact through third parties, unless, Judge Rothschild says otherwise, okay? Good luck to you. You can address that on Thursday. Thank you.
Thank you.
Terry John Thomas? Yes? Okay. Well, it's actually an ad charge.
Is that Maine?
I show him as Maine.
He's here at Main, Judge.
Are you Mr. Terry John Thomas?
Right.
Okay,
Yes,
so
he
you
is.
have a KP as failure to register a vehicle that was issued March 6th. What's 1, 2, and 3? We know?
He's got a county sentence, Judge. I don't think there's anything else holding him other than that county sentence. I don't know when that ends.
I have an offer. He's due for release April 2nd. I have an offer if he wants to resolve the failure to register.
Sure.
Offer to be time served.
He wishes to accept this offer, Judge.
Okay, time to pay $293. Or unless this is part of another case, then I don't have to do court costs.
No, it's not.
So
He
$293.
needs 1 year, Judge.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
Okay, is your name Terry John Thomas, Thomas?
Yes.
Put your hand down. It's my understanding you wish to waive your right to a trial.
Yes.
Anybody forcing you to do this?
No, ma'am.
Ever been treated for a mental illness, sir?
Nope.
Okay, you can put your hand down. Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
Pleading no contest to, get the right name, Failure to register a vehicle, sir?
Yes.
Okay, the court's gonna adjudicate your time, serve you, impose court costs which are required by law, $293. The court's gonna give you 1 year to pay that. The court does accept your plea. Find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, sir, okay? Except for paying the $293. Good luck to you.
Good luck, sir.
Kenneth Banks, and then we have Brian Williams.
Mr. Banks is approaching. Come on up, sir.
Sorry, say that again? Okay, sir, you have, I believe this is an ad charge for petty theft prior conviction. This is actually count 2. Anybody wish to be heard with regard to the bond?
State's offer, if Mr. Banks wishes to resolve it, would be an adjudication, time served, no return to Lowe's Home Improvement in Pompano.
He wishes to accept the state's offer.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, your name Kenneth Banks, B-A-N-K-S.
Yes, ma'am.
Put your hand down. It's my understanding you wish to waive your right to a trial.
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Want to plead no contest to petty theft prior conviction?
Yes, ma'am.
You understand that if you get another petty theft, it's possible that they will charge it as a felony, sir.
Yes, ma'am.
Understanding what I just explained to you, you're pleading guilty or no contest to petty theft?
Yes, ma'am.
No contest?
I'm in contest, yeah.
Court's going to accept your plea, find that it's freely and voluntarily given. The court has reviewed the court file, sir, and finds probable cause for the plea. The court's going to adjudicate your time, serve you, impose $293 in court costs. The court will give you 1 year to pay that. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, sir, except for paying the $293 within a year. Thank you. Brian Leonard Williams, and then
He's
we
in-
have Kevin Puryear.
He's in Conte, Judge.
Yes, ma'am.
Thank you, Sheila. Okay, are you Mr. Brian Leonard Williams?
Yes, ma'am. Lenard.
Bernard, I'm sorry. Leonard. Brian Leonard Williams, okay.
Yes, ma'am.
All right, sir, you have a KPS traffic unlawful license tag sticker attached. This is charge 8. Does he wish to resolve this, or what are we doing with this?
My advice to Mr. Williams would be to not resolve it. He has no bond holds on court orders on counts 5, 6, and 7. He's got a $250,000 bond on count 1. So I don't think it would behoove him to enter into any kind of negotiations on this.
Okay, court will set his bond at $99. Thank you.
Thank you, Judge.
Kevin Puryear. Then we have Humberto Iglesias.
I want to refer you to President Judge of the municipal ordinance case.
Okay, Mr. Puryear, you have 1 count of capious misdemeanor for panhandling. You want to resolve your case today?
Yes, ma'am. I would like to resolve this case by pleading no contest.
Okay, are you going to agree not to go back to this location, sir?
Yes, ma'am.
Because if you come back here and I see that you've been panhandling again, you're going to probably receive, a harsher sentence. Do you understand that?
Yes, ma'am. You won't have any problem no more, ma'am.
Okay. Sir, raise your
Thank
right
you,
hand.
ma'am.
Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Is your name Kevin Puryear, Puryear?
That's correct.
It's my understanding you wish to waive your right to an attorney and trial, sir?
I don't understand.
Are you giving up your right to have a trial in exchange for pleading no contest, sir?
Yes.
Is anyone forcing you to do this?
No, ma'am.
Okay, you understand that if you can't afford an attorney, one can be appointed for you.
What's
Do you understand, sir? So you want to plead no contest today, sir?
Yes, ma'am.
Okay, and
no
when you plead no contest, you have to give up certain rights. That means you're telling me you don't want a trial in this case, correct?
Right, no trial.
Okay, do you want the court to appoint an attorney for you?
No,
Because if-
ma'am.
Okay. You ever been treated for a mental illness, sir, that would affect your ability to understand the nature of these proceedings today with clarity?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication?
Yes, I was on alcohol when I got
No, right
arrested
now,
in the
sir, right now, are you under the influence of
No,
any?
ma'am, no, ma'am.
Let me finish the question. Are you under the
Okay.
influence right now of alcohol, drugs, or medication, sir?
No, ma'am, no, ma'am.
You understand that if you're not a U.S. citizen, a plea to discharge could result in deportation proceedings, sir, and affect your ability to remain in the United States.
Yeah, I understand that, but I was born and raised in the United States.
Okay. Understanding what I just explained to you, do you want to plead guilty or no contest or not guilty to panhandling,
pleading.
sir?
I'm pleading, I want to resolve this case by pleading no contest.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court is going to sentence you to an adjudication and time served, $78 in court costs. The court will give you 6 months to pay the $78 in court costs, which I have to impose by law. You have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. You're done with this case, sir. Thank you. No
Okay, thank you,
return,
ma'am.
sir. No
Yes,
return.
ma'am.
Humberto Iglesias, and then we have Sylvester Thames.
North Broward.
Okay, are you Mr. Humberto Iglesias?
Yes, Your Honor.
Sir, you have a DUI, alcohol, or drugs first offense, bond's been set at $500. Then you have count 2, DUI with an unlawful blood alcohol level of greater than .15. Any objection to probable cause, Mr. Reedy?
No, Your Honor.
Court finds probable cause. Bond's been set at $1,500 total. Anybody wish to be heard?
Just requesting that the bonds be kept in place in light of the driving pattern and Mr. Iglesias' breath results.
Judge, Mr. Iglesias has been living here in South Florida all his life. In fact, he's been staying at the same place his entire life. He does have family here, including his mother and brother, and he indicates to me he would be going back to your mother's house, right, Mr. Iglesias? That's where he would
In
be.
Hialeah?
In Hialeah, right? Yes, that's where he would be going, Judge. I don't know the extent of his prior criminal history, but he does have family here, including not only his mother where he can stay, but also his brother. I don't know, and Mr. Iglesias doesn't know if they're going to be able to come up with $1,500 in bond. I'd ask the court to consider pretrial release with a condition of no alcohol or other substances.
Okay, state, what's his priors?
An 09 theft, and it does appear he had resources to purchase the vehicle involved in this less than a week ago.
What type of vehicle was that?
Not sure, Your Honor.
It's a gray Nissan.
What year?
Don't know, doesn't say. What year is the car, Mr. Iglesias?
04.
What is it?
2004.
2004?
Okay, no alcohol or intoxicants, standard pretrial release, ROR on 1 and 2.
Thank you, Judge.
You understand, sir? No alcohol or intoxicants. Don't violate the court's order. Thank you. Sylvester Thames? Yes, ma'am. Sylvester Thames? Is there any Sylvester Thames?
Judge, I've been advised he bonded.
Bonded? Robert Bruce Casper?
Mr. Casper is here, President Maine. He is approaching, Judge. Come on up, Mr. Casper.
Then we have Jeffrey Alexander after this. Okay, Mr. Casper, you have trespassing. Do you want to resolve his case today?
He does, Judge.
Okay, state.
Your Honor, this is someone's private property, resident's private property. I have no offer at this time.
Okay, court will adjudicate time served, no return.
State objects to any offer being made where victim does not have an opportunity to address the court.
Okay,
Judge, Mr. Casper wishes to accept the court's offer.
can you give me the address?
2415 Sherman Street, Hollywood, Florida.
Does your client understand that he's not under any circumstances to return to this address?
He does, Judge.
How much time to pay the $293?
1 year, Judge.
Sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, put your hand down. Is your name Robert Bruce Casper, Kasper?
Yes, ma'am.
It's my understanding you wish to waive your right to a trial, sir?
Yes, ma'am.
Is anyone forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Want to plead no contest to trespass a structure or conveyancer?
Yes, ma'am.
You agree not to go back to the property located at 2415 Sherman Street, Hollywood, Florida?
Yes, ma'am.
Okay, you satisfied with the advice of your attorney?
Yes, ma'am.
Okay, yes.
It's a structure, not a conveyance.
Okay, structure? Not what my paperwork says, but okay. Okay, so you want to plead no contest to trespass of a structure?
Yes.
Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Adjudication, time served, $293 in court costs. Court will give you 1 year to pay. You're not to return to 2415 Sherman Street, Hollywood, Florida. You understand, sir?
Yes, ma'am.
Okay, you're done with this case, except for paying the $293. In 1 year, Mr. Romero will explain to you what happens if you don't pay the $293. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you. Okay. Jeffrey Alexander. Okay, Mr. Alexander, you are charged with petty theft, second degree, first offense. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause. I can tell you, sir, you're not to return to the Walmart located at 1800 South University Drive, Miramar, Florida. Okay, anybody want to be heard with regard to the bond?
Judge, I just want to verify, I believe this is Mr. Alexander's first offense?
It says second degree, first offense. That's what the paperwork says. Now, whether it is or not, I don't know, but that's what it
inquire with
says.
Mr. Lender.
Again, if he had priors, I would certainly advise the court.
Okay.
I don't know if we maybe went too quick for Mr. Lender, and that's why he didn't have time to
Okay.
look it up. 'Cause,
I can keep up.
I asked, does anybody
oftentimes
wish to?
he gives us additional information after he finished speaking, Judge.
All right. Supposedly his first offense. There's no return to Walmart. What are we doing with this case? 25.
I would advise him not to resolve this case. I know he kind of whispered to me that he did, but he has no prior offenses. He may be eligible with some sort of diversion program.
ROR Walmart. No return to Walmart. Thank you.
Thank you, Judge.
Stephen Carrera. Carreria. Correa. Hello. Good. Stephen Carreria. Correa. Anybody there?
Mr. Correa? He's
Come on up,
approaching,
sir.
Judge.
Then after that is
Mr.
Mario David Leonard.
Mr. Correa is here present, Judge. How you doing, Your Honor?
Good, sir. How are you?
I'm okay. I can't complain.
All right. Petty theft. You're charged with petty theft, first degree. Property between 100 and 300 from Publix on 1003 East Commercial Boulevard. Any objection to probable cause?
Probable cause seems to indicate that the amount of items stolen, although it doesn't say what those items are,
$20.
is $20.06.
Correct. And your point? Any particular point you'd like to make?
Well, it's not between 100 and 300.
On the flip side, he has a prior theft, so this would be a second, which would make it a first degree misdemeanor.
Okay, so I guess that's from the clerk, the way they do it in their computer. So this is a petty theft, first degree misdemeanor, second offense. Any objection to probable cause?
Well, again, doesn't say what exactly it is that he took, but I think there's enough for probable cause.
Okay, there's no return, sir, to Publix located at 1003 East Commercial Boulevard, Oakland Park. Do you understand, sir?
Yes, ma'am.
Okay, anybody wish to be heard with regard to the $100 bond?
Yes, Judge, and speaking of Mr. Correa, he wishes to resolve this case, but as, it was stated, he does have one prior, petty theft. I believe the allegations here was from Publix, a sub. The merchandise was recovered, so there's no outstanding restitution issues. Judge, I'd ask you under these circumstances, considering it's food, I'd ask you in this case to withhold adjudication so that, he doesn't have a conviction on this and judicial notice of time served. He has no problem fighting. He will not return to that Publix. And from what Mr. Correa told me, you will not see him again under these circumstances, Judge.
Your Honor, one moment.
Case are you here on? Any particular one? Okay. I thought you were here on a case, I'm sorry.
Your Honor, the state's offer would be an adjudication time served. He does have the prior theft. He also has a prior. Two prior DWLSs, it looks like two prior possessions of cannabis.
Okay, the court would adjudicate and time served. If he wants,
Judge.
if he wants, the court will oral arm. Hold on. Okay, adjudication, time served.
He'll accept the court's offer for adjudication time served, Judge.
Okay, if he can't, I don't want him admitting to this, I can ROR him and he could return back to court, so it's up to him.
I did, and he
You
wishes
okay,
to-
Your Honor? Thank you so much.
Okay, raise your right
Thank
hand, do you
you.
swear and or affirm to tell the truth?
Yes, ma'am.
Okay, your name is Stephen Carreri, C-O-R-R.
Korea, sorry.
Go ahead,
Correa, Korea. It's a Spanish word.
Korea, okay.
Yes, ma'am. I said I need a time for it.
Okay, sir, it's my understanding you wish to waive your right to a trial?
Yes, ma'am.
Put your hand down, is anyone forcing you to do this?
No, ma'am.
Are you under the
Are you
influence
forcing-
of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No.
You agree not to return to the Publix at 1003 East Commercial Boulevard, Oakland Park, Florida?
Yes, ma'am.
Okay, you spoke to your attorney about that if you get another charge like this, it could be enhanced to a felony.
Yes, ma'am.
Okay, and understanding that, you want to plead no contest to
Yes,
petty
ma'am.
theft, first degree?
Yes, ma'am.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Court's going to adjudicate your time, serve you $293 in court costs. No return to Publix at 1003 East Commercial Boulevard, Oakland Park, Florida. Time to pay.
1 year, Judge.
Okay, the court will give you 1 year to pay the $293. If you can't afford an attorney, one will be appointed. You have 30 days to appeal. Thank you, sir. You're done with this case.
Good luck.
Thank you.
Have a good day.
Mario David Leonard.
He's here present, Judge, at Maine.
Okay, Mr. Leonard, you have count 1, DUI, alcohol or drugs, first offense, $500 bond. Counts 2 through 6 are DUI with damage to property or person of another. Bond's been set at $1,000 each count, so that's $5,500. And then you have one more. Count 7, driving while license is suspended, first offense. Bond is set at $100 for a total of $5,600. Any objection to probable cause?
I see probable cause for DUI with property damage. Let me just have 1 second, Judge, to add this up. I did before.
5 counts. Mr. Reedy
Four counts.
says 5.
So 1, 2, 3, 4 counts.
You are correct, 4 counts.
So no probable cause argument.
Okay, one moment, sir. I stand mistaken. So you have DUI alcohol, first offense, 1 count, and then 4 counts of DUI with damage to property of another. Count 6 is DUI with an unlawful blood alcohol level of greater than 15 or accompanied by a person under 18 years of age. And then 7 is driving while license is suspended. So it's $5,600 in bond total. Court does find probable cause. Anybody wish to be heard with regard to the $5,600 bond?
Your Honor, I'm gonna be asking that the bonds be kept in place with pretrial release and a TAD monitor, no alcohol, no intoxicants, no driving until further order of the court until he has a valid license. Your Honor, in this instance, I don't believe the TAD monitor is really a mitigating consideration. I think it's necessary in combination with the bond.
Tell me why.
Yes, Your Honor. First off, I believe Mr. Leonard poses a danger to the community. In this instance, getting in an accident while under the influence when he's not even supposed to be behind the wheel, sending 2 people to the hospital for treatment and with the high breath, enhanced breath results. Additionally, Mr. Leonard has 12, according to his driving record, he has 12 prior DWLSs. Out of Marion County in 2008, he was sentenced to 13 months in state prison for felony DWLS. He absolutely.
Driving record on this gentleman? This is Mario David Leonard.
He absolutely refuses to not drive. He also, one moment, Judge. In Broward County in 2007, he had a theft.
Thank you, ma'am.
It would appear he not only stole a tag to a car, but altered it so he could drive, trying not to go detected because his license was suspended, and he was convicted of theft, altering a vehicle tag, and DWLS. So not only will he's shown that he will drive when he's not supposed to, but he will take active efforts to conceal the fact that he's not legally allowed to drive, to get behind the wheel. And he also had a felony DWLS in Broward in '04.
Hence,
Judge, in speaking to Mr. Leonard, right now the bond that is currently set, if my math is correct, is about $5,600 bond. He's not going to be able to afford that. Unfortunately, he was working. He lost his job. He was making about $300 per week. Right now, he's 36 years old, been living here his whole life. He rents an apartment in Hollywood. He's been there for about 2 years. He doesn't think, he does have a brother that lives in Miami, but he doesn't think that he can afford a post bond. He has no savings to post a bond, cannot afford any sort of monetary bond. We have no problem as far as what the state requested as far as their pretrial conditions, with pretrial monitor, TAD monitor, Judge, but at this time, what he's asking you is to impose those conditions and not the financial monetary bonds associated with counts 1 through 7, Judge.
what does he do for a living?
He was working, like I said before, he was working, I believe, at Rapid Rooter. He lost his job. He was working there for about 1 year, making about $300 a week. He lost his job, so right now he's unemployed. So therefore, that's why he can't afford anything, Judge.
Okay, court's gonna order no alcohol or intoxicants, TAD monitor and random testing, GPS level 2, no driving, sir, without a valid license. Court's gonna set bond on count 1 at 500. On counts 2, 3, 4, 5, and 6, court is gonna set bond at $500 per count. Court will leave the $100 in place. So 1 through 6 is $500. And then 7 is $100. Thank you. Eric Rion Jones.
North Broward.
I'm sorry, Tetrick Rion
Yes.
Jones.
Judge, Mr. Jones has a no bond hold on count 1 and 2. Would be asking the court to leave the $1,000 bond in place on count 3.
Okay, any objection to probable cause?
No, Your Honor.
Okay, court's gonna set the bond at $999. Any no victim contact or it? Oh, wait, can't. All right, $999. Thank you. Cedric Cornelius Johnson.
Mr. Johnson's here present, Judge? He's going, man.
Cool.
Hey, man.
Huh? Hey, Madam Clerk, here you go. Okay, Cedric Johnson, thank you.
He's here at Main, Judge?
Okay, Mr. Johnson, you have add charges. Count 8 is burglary of an unoccupied conveyance unarmed. Count 9 is petty theft, second degree, first offense. Any objection to probable cause?
No, Judge.
Okay, I can tell you there's gonna be no victim contact, direct or indirect, with the alleged victim, whose name is G. Tara Brahme. No contact means no contact in person, telephone, texting, through social media, or third parties. You understand?
Yes, ma'am.
Okay, state, bond.
Your Honor, his total bond is, on his other charges, is $13,525 plus pretrial GPS. On his 2 other burglary conveyances, bonds are set at $2,000 each, so I'd be asking for the court to set the bond on the burglary here at $2,000.
Okay, defense.
Judge, currently he has, other matters pending. As the state said, $13,525. He's gonna be relying on his parents to post his bond. They might have already. They're retired, so all his financial resources of the parents already went to pay different bonds that he was currently already frustrated on. These are ad charges. Considering, Judge, that, I believe the court, besides imposing a monetary bond, the court imposed level 2 pretrial. We'd be asking you to consider on these, 2 ad charges on 8 and 9 for pretrial level 2, with the monitor, Judge. He's right now working in landscaping. His parents, they don't have, I don't think they have any more money from what Mr. Johnson said, so that's why the nature of our request, Judge.
Okay, so they're bonding him out on $13,525, you're saying?
I believe so. I believe they used up all their savings and came up with the premium with the bondsman, so that's why I believe it's been exhausted. And that's why I'm asking for level 2 pretrial on 8.
I just think it's aggravating and more serious. The more burglaries we're learning about that he's committed, Your Honor.
Okay, no victim contact, direct or indirect, GPS level 2, $1,000 bond. Thank you.
Thank you, Your Honor.
Next one is Tracy Peoples, and then we have Christopher Ronald Roger.
Mr. Peoples, I believe this is the 3rd time he's been here, Judge, just now.
Oh boy, how are you, Mr. Peoples? Nice to see you again.
How you doing, Mel? I see you.
All right, nice to see you. Okay, so we have add 6, an ad charge for count 6, parole violation. He's gonna be held no bond.
Judge, correct me if I'm wrong. I know yesterday, I believe we were here, same nature. I believe maybe originally it was thought he was on probation. Then I don't know who was speaking. I believe they informed the court that no, there's no probation holds. There may be a parole violation, but I don't know if this was already addressed yesterday. I'm not sure.
This is the one where we deleted 4 violations of probation. Was this the case? I
Yeah,
believe
Mr.
so.
Romero's wrong. We were advised he's on a parole hold, and that's exactly what he's here on today, a parole hold.
Okay, so today is the parole hold. Yesterday was an error, okay?
Yeah. The parole hold is the only thing holding him.
Okay, all right.
Good luck
All
to
right,
you,
hopefully
sir.
it's the last time, because I know they talked about this yesterday, even though Mr. Lennon said no, but they did talk about it yesterday.
Okay, Christopher Ronald Roger. Good morning, sir. You have resisting an officer or obstruct with violence. Any objection to probable cause?
No, Your Honor.
Okay, court does find probable cause. Let's talk about bond state.
One moment, Your Honor. Your Honor, I'd be requesting a $500 bond.
Okay, $500 bond.
That's reasonable, Judge.
Okay, court will set bond at $500. Okay. Next one is Michael Hart Bray.
Mr. Bray, come on up, please. Top of the day to you, Your Honor.
Top of the day to you too, sir. So you have a charge. You have actually two capious felonies. One is possession of cocaine. The other one is unlawful assembly. The capious felony is a no bond hold. You are going to be going before your division judge, who has requested that you be held no bond pending your hearing on March 19th, 2018. Is that next Monday? I need a calendar here.
Yes.
Okay, next Monday, sir, at 8:30 a.m. on the capious misdemeanor, sir, you have a bond of $50 for the unlawful assembly. Court does find probable cause. Anybody want to be heard with regard to the $50 bond?
I have no
It's a municipal ordinance case.
Is it?
Yes, ma'am.
Okay, I'm not gonna resolve it today. So, tell you what, on the municipal ordinance case, court will set his bond at $9. Thank you. Jose Fernando Serrano.
Mr. Serrano's approaching, Judge, and he can find the service of public defender.
Your Honor, I was trying to, I have ADHD, there's too much stuff going on in the courtroom, it was going a little too fast for me, and I was trying to tell, the gentleman that I would like to get a part, but I didn't want to deny myself a public defender. Sorry, it was just,
That's all
Too
right,
much
you don't
of a-
have to worry about it, sir, it's no big deal. You can talk to Mr. Romero, we'll recall your case, okay? Go
I mean,
ahead.
I'm ready to go for it.
Okay, Mr. Romero, do you want to use the services of the public defender?
Yes, at this time.
Okay, so, Mr. Romero,
Yes, Judge.
he'd like to use your services, so talk to him for a moment. Let me just tell you, sir, you're charged with one count robbery with a firearm. There has been a warrant issued for your arrest. Judge Fine, I believe it is, has requested that a bond be set at $25,000. Go ahead, Mr. Romero, and let us know when you're ready, okay?
Thank you, Judge.
Is there anybody at North Broward? Let me
I think
see.
so, Judge. I think we're
Is
done
there
with.
anybody at North Broward, Deputy? Anybody have anybody at Conti? Okay, I think those are done. Okay, so we just have the main jail. Okay, next person after this one is going to be, just cut this. Bruce Hodgson, then Lazaro Penton Cruz. Okay, your name is Bruce Hodgson, sir?
Yes, ma'am.
Okay, sir, you are charged with one count, burglary of a dwelling or conveyance armed. Any objection to probable cause?
I don't see how it's armed.
It's not, it should be probable cause for burglary of a structure.
Okay. Burglary of a dwelling of a structure. You said a dwelling or a structure?
Structure.
Any objection to probable cause for burglary of a structure, Mr. Reedy.
Not to that lesser charge, Judge, no.
Okay, the court does find probable cause. The court's gonna tell you, sir, you're not to have any contact. Not to have any contact, sir, with the alleged victim in the case with the initials YLH. That means no in-person contact, no calling, texting, any contact at all whatsoever through social media, and no contact through third parties. You're also not to return to Fat Boy's Barbecue, which is located at 204 South Power Line Road. I believe that's in Deerfield Beach. Do you understand, sir?
Yes, ma'am.
Okay. So, state, what's your comments as to, what's your request as far as bond?
Requesting a $5,000 bond. Mr. Hodgson was arrested on a failure to appear February 3rd of this year, July in Boca Raton last year. As far as Broward goes, he had on state priors, trespass last year, resisting without violence 2013. Actually, one moment, Your Honor. Disorderly intoxication, failure to leave property upon order from owner, failure to leave property upon order from owner, failure to leave property upon order from owner, trespass 2012, failure to leave property 2012, trespass 2011, failure to leave property 2011, resisting without violence 2011, disorderly conduct 2010, loitering and prowling 2010, resisting without violence 2010, trespass 09, trespass 09, trespass 08, trespass 08, trespass 08, battery 08, trespass 07, burglary of a structure and theft 07 with the violation of probation, disorderly intoxication 05, and I'm showing 5 previous failures to appear total.
It also says your client's at large. Okay, so $5,000 bond, defense.
Judge, in speaking with Mr. Hodgson, unfortunately, he's financially indigent. He's 43 years old, been here his whole life. Unfortunately, he's not working. Unfortunately, he's homeless. However, from what he advised me, he does have a mailing address. It would be of his father who resides in Lauderhill.
Okay, give me that address.
What's the address? 6100 Fall Circle South Drive. Okay, say it nice and loud so the judge can hear you, okay? 6100 South.
6100?
Yes, South Fall Circle Drive.
I'm sorry, I can't understand him, Mr. Romero. 6100.
6100, correct? Yes. South Falls Circle Drive.
South Falls.
Circle Drive.
Okay, is there an apartment number?
Yeah, apartment 107, building 106. Building 7. Building 7, apartment 106.
Building 107, apartment
Bro,
106.
Building 7, apartment 106. Building 7, apartment 106, Judge.
What town is that?
Lauderhill.
Zip?
33319.
19?
Yes, ma'am.
Okay, Mr. Romero.
Judge, so
And
therefore,
keep in
that's
mind,
the
he's failed to appear 6 or 7 times, and he has quite the prior record.
Right, but doesn't change my position. He's financially indigent. I'm still going to be requesting, Judge, for you to consider releasing him on level 2 pretrial.
Can he live with his dad?
That's what I was trying to get into that conversation. I do not believe so, Judge.
Mr. Linder, is there something you'd like to add?
Hunter, I just, you know, I understand, I wouldn't say I understand. The only mitigating factor Mr. Ramirez presented is that he's indigent. The aggravating factors heavily outweigh that one factor. So I don't see how one mitigating factor can outweigh all those other factors to the point that a non-monetary bond would be appropriate. Or non-monetary release, I apologize. Considering public safety shall be the overwhelming consideration in this division pursuant to Judge Tudor's administrative order in the circuit.
$5,000 bond, no return to Fat Boys, no victim contact. Clerk to update the address. Thank you, sir.
Yes, Judge.
Cruz, Lazaro, Penton.
Mr. Penton is here approaching Judge at Maine.
Judge, my paperwork's like the other gentleman we had before. I was missing the first 13 counts. I don't know if you have the same.
Who?
Mr. Penton Cruz.
Oh, he has 1 through 25.
Okay, I just didn't know. I didn't know.
Yeah. All right, and then we'll go back to Mr. Serrano after Mr. Penton Cruz. Okay, are you Lazaro J. Penton Cruz, sir?
Yes, ma'am.
Okay, sir, you are charged with count 1, possession of burglary tools with intent to use. Bond's been set at $1,000, and you have counts 2 through 5. We need to talk about bond, which is burglary of an unoccupied conveyance unarmed. Then you have counts 6, 7, and 8, which is grand theft between $300 and $5,000. You have also count 9, the same thing, bond set at $1,000. So we have $5,000 total. And then count 10 is a $25 bond, failure to register a vehicle. Count 11, driving while license is suspended. Third or subsequent offense, I believe they're charging that as a felony. I'm not correct, state, let me know, of $750. Count 12 is driver's present, non-current proof of insurance, $100 bond. Count 13 is a probation violation or community control. I can tell you, you are going before your division judge, or Judge Ernest Calra, on 3/20, which is, can I have the calendar, please? March 20th, which is a week from today, sir, at 8:30 a.m. Then you have count 4, possession of burglary tools with intent to use, $1,000 bond. Count 15, burglary of an unoccupied conveyance unarmed. We need to talk about bond for that. Count 16 is another grand theft, $1,000. 17 is another probation violation. 18 is another burglary tools along with count 22, that's $1,000 bond. Then you have burglary of an unoccupied conveyance, count 19 and 23. Then you have another grand theft on counts 20 and 24, $1,000 bonds on that. And then count 5 is another probation violation or community control, which are all, the probation violations or community control, you're being held no bond. Any objection to probable cause?
No, Judge.
Okay, the court does find probable cause. Let's talk about bond.
Your Honor, on counts 2 through 5, I'm going to be requesting bonds in the amount of $10,000 each. On count 15, $10,000. Count 19, $10,000. Count 23, $10,000. Your Honor, I have great concern for businesses in both Dade and Broward County. Noting the allegations in these reports, also noting Detective Burstein's report, which states that Mr. Penton Cruz made a post-Miranda statement explaining that he has been stealing spare tires and rims for 8 to 10 years, and that he typically steals tires 3 or 4 nights a week throughout Dade and Broward counties. Your Honor, I would also note the case that Mr. Penton Cruz is on probation for, burglary of a structure, grand theft. He was placed on 2 years probation. He was just placed on probation December 12th of last year, 2017. Additionally, out of Dade County in 2011, he was convicted of grand theft, sentenced to 1 year and a day state prison. He also has a prior conviction for loitering or prowling. And I see 1 prior failure to appear.
Okay, defense.
Judge, in speaking with Mr. Penton Cruz, at this time he's unemployed. He was working at a closet factory, making about $13 an hour. Unfortunately, he's not working at this time. He's 56 years old and living here in our community majority of his life for about 40 years. He lives in Miami Garden. He rents an efficiency. He lives there by himself. His monthly rent is about $400. Judge, at this time, there's no way he's going to be able to afford the monetary bond that the state is suggesting. I do understand, however, he has no bond holds on his probation case. He's going to have to appear before his probation judge. Judge, I'd ask you on counts 2 through 5 to set $1,000 on each count. I'd ask on count set $1,000, count 19, $1,000, 23, $1,000. I believe $1,000 bond on a third-degree felony would be appropriate considering he has no bond holds on his violation cases, Judge.
Okay, state. What about no return? Give me the name of the businesses, please.
Might be missing some. Southwind Irrigation
Hold on. Sir, you're not to return to Southwind Irrigation.
on Hiatus Road in Sunrise.
Okay,
Solier Media,
spell it, S-O-L.
Ayre,
Okay,
on Hiatus Road in Sunrise.
Solier Media.
Yes, ma'am.
Okay, next place.
Warren Duke Incorporated on 53rd Street in Sunrise.
Okay,
Your Honor, that's all I have here. I don't know if you, one moment, Judge.
okay, sir, there's no return to Southwind Irrigation, Solier Media, Warren Duke, or any other place that's alleged that you burglarized. Court's gonna set bond on count 1 at $1,000. On counts 2, 3, and 4, court's gonna set bond at $10,000. Each count 6, 7, and 8 is $1,000. Count 2, 3, 4, and 5 is 10,000. 1 is 1,000. 2, 3, 4, and 5 are 10,000 per count. Count 6, 7, and 8 are $1,000. Count 9 is $1,000. Count 10 is $25. Count 11, $750. Count 12 is $1,000. Count 13 is no bond. Count 14 is 1,000. Count 15 is 10,000. Count 16 is 1,000. Count 17 is no bond. Count 18 is 1,000. Count 19 is 1,000. Count 20 is 1,000. Count 21 is no bond. That's the violation. Count 22, 23, and 24 or $1,000, and count 25 is no bond. Hold on, no, count 12, I'm sorry, is $100. Okay, I put them on the sheet here. You can look at them on there. Thank you. Next one is Jose Fernando Serrano.
He's here, Judge. That was the gentleman that you put on recall so I can talk to him, but I think the other two gentlemen, Judge.
All right, so go ahead, go talk to him. We'll wait for you. Unless you'd like to reset him for this afternoon, it's up to you.
No, Judge, we're here.
Okay, take your time. Just remember, it's a warrant to arrest. wait, I have one here. This is one, it's supposed to be 2 14 days. This was supposed to be a space, a whole name. Guess I read that.
Judge, we're ready to proceed. Thank you for giving me that opportunity.
You're welcome, Mr. Romero, anytime. Okay, sir, you're charged with a robbery with a firearm. It's a warrant to arrest. Judge Fine did set a $25,000 bond. State?
Your Honor, the state is going to be seeking a no bond hold. This is a robbery with a deadly weapon. I believe there is proof evident or presumption great. The allegations support the elements of the offense. The victim.
Yes, hold on one moment. What, Madam Clerk?
Page 15.
You're welcome. Go ahead.
The victim identified him. He's also personally known to the victim. And, Your Honor, I would note that Detective Augusti pulled video surveillance of the incident from Broward County Transit. And he states that the incident can be clearly seen. And what is seen on the video corroborates the victim's version of events. So the state would be seeking, and I understand Judge Fine said a $25,000 bond, but upon a finding of proof evident or presumption great, should the court make such a finding, we would be seeking a no bond hold.
Okay, defense?
It's a robbery with a knife, Judge. We would object to the court making a finding of proof evident presumption great based solely on an affidavit introduced by the state. If there is a videotape of this incident, that should be presented to this court. If the state is going to be asking the court to impose the most serious restrictions of pretrial detention on Mr. Serrano, which is to have him held no bond, they've called no witnesses, introduced no evidence whatsoever. Barring that, the court still has discretion to establish bond or set bond, even if the court finds proof evident presumption great. Judge Fine posted a bond on this and felt it was appropriate after reviewing the warrant that's before the court now of $25,000. I don't know if Mr. Serrano is ever going to be able to make a $25,000 bond, but I would either ask the court not to make a finding of proof evident presumption great and set bond for Mr. Serrano, or in the alternative, to leave the bond as previously set by Judge Fine.
Okay, Mr. Serrano, I have reviewed the probable cause affidavit in your case, and it says robbery with a firearm or deadly weapon. Just want you to know. And I do find probable cause. I further find the proof of guilt to be evident or the presumption great. The court is going to set bond at the $25,000. There's going to be no victim contact, direct or indirect, with the alleged victim. What is the name?
Your Honor, the alleged victim's initials are OB.
Oscar Bravo?
Yes.
Okay, there's going to be no victim contact, and I'll hear you guys with regard to the bond in a moment. There's going to be no victim contact, sir, direct or indirect, with the alleged victim, with the initials OB. That means no contact in person, no calling, no texting, no contact through third parties, no contact of any kind whatsoever through social media like Facebook, likes, dislikes, or anything like that. Okay, sir, do you understand? You're also not to possess any firearms, ammunitions, or weapons, and you're to surrender same to your local police department immediately upon your release. You're gonna have a GPS level 2. Go ahead, state.
I was just gonna be requesting the GPS, so, Your Honor, I have nothing further. I would
Okay.
just ask that the court keep the bond, where Judge Fine said it then.
Okay, defense?
Judge, in speaking with Mr. Serrano, he's 32 years old, been living in our community for now 20 years. But he advised me he's self-employed, he's a handyman by trade, so his wages fluctuate. But on an average, he makes about like $400 per week. He lives in Miami with his sister. His sister right now is a secretary helping out with the share of the apartment expenses, such as the rent. He's going to be relying on his sister to post his monetary bond. However, from what he informed me, he has no savings. His sister's going to be the one that's posting bond. The $25,000 bond that's currently at this point, I guess, from what the state is at, or what Judge Fine ordered, at this time is financially out of his reach. Judge, we have no objection as far as level 2 supervision. We'd be asking you to consider lowering it from $25,000 to $5,000. He would still be supervised. He'd still be with the monitor. He would still have to report in. We feel that would be appropriate under circumstances, Judge.
Just want to advise the court, as it's already mentioned, the alleged victim sought and obtained a restraining order against Mr. Serrano in 2016, and a woman in Dade County in 2012 obtained a injunction order of protection against Mr. Serrano.
Court's gonna keep the bond at $25,000, no victim contact, GPS level 2, no firearms, ammunition, or weapons, surrender them to the local law enforcement immediately upon his release, without prejudice for him to go before his division judge.
Your Honor, I apologize. The court, I believe the court ordered no firearms, weapons, ammunition.
Yes, surrender. Thank you. It's all right, I understand. Eric Carl Hines, and then we're gonna have Emery Jones, please. Okay, Mr. Eric Carl Hines, you're charged with one.
Judge, one last question, Judge. I apologize because
Sure.
Mr. Serrano, could you sign a phone order?
Sure.
Thank you, Judge.
Pardon? What is it?
Mr.
No, I don't
Judge,
need
who
that.
did you call next?
Here you go. Look at this.
Mr. Eric Hines is here present, Judge, I mean?
Doesn't matter, either one. Okay, I'm sorry, Mr. Romero, what did you say?
This is Mr. Eric Hines, Judge, and he declined to serve as public defender.
Okay, Mr. Hines, you have driving while license is suspended, $100 bond, and you also, I know, have 2 capious felonies which you have no bond hold. That is for grand theft, and that is for no valid motorcycle license, that's a capious felony, pending before Judge Bailey. So the only thing we have to address, sir, is the $100 bond on driving while license is suspended. Second offense, can you afford the $100 bond, sir?
Yes, ma'am.
Okay, why was this given to me? Okay. Okay, I'm sorry, sir. Keep getting interrupted. All right, so driving while license is suspended, can you afford the $100 bond, sir?
Yes, ma'am.
Okay, so you are gonna be held no bond on counts 2 and 3. So wait till you resolve those cases till you bond out, okay?
Okay, ma'am.
Thank you, sir. Good luck to you. Emery Jones?
Mr. Judge, is here present, Judge, I mean? Good
Okay,
morning.
good morning, sir. How are you today?
I'm all right.
Okay, sir, you have 3 violations of community control. You're gonna be held no bond in those cases. You do have a hearing before your division judge, Judge Michael Lynch, on March 20th, which is a week from today. It's a Tuesday at 9 a.m. And then you have a capious traffic, which is it's gonna be set in that division. I believe it's Division MS.
On the KPS traffic.
OMD, I'm sorry. Driving while license is suspended, it's gonna be set in that division. That's Judge Mindy Solomon. So pending the hearing, sir, you're gonna be held no bond on 1, 2, and 3, is ordered by your division judge, and count 3 is 500, so we'll leave it in place. Okay, sir, you have a hearing next week on your felonies.
Can I resolve all right, thank you, ma'am.
I'd rather not resolve it because it might hurt you in your case, okay?
All right, yeah,
Thank you, you're welcome. James or Jamel Lenward Roll, and then we have Marlon Tremaine Meggett. Okay, are you Mr. Jamal Lenward Roll, sir?
Yes, ma'am.
Okay, sir, you have operating without a valid DL and a probation violation. You're gonna be held no bond on the probation violation. You're going before your division judge on Thursday for your felony at 8:30 a.m. Your division judge is Judge William Howery. For operating without a valid DL, the court does find probable cause, bond set at $25. Anybody wish to be heard?
No, Judge.
Okay, so the court's gonna set the operating without a valid DL at $9. Thank you. Marlon Tremaine Meggett.
Mr. Megas here, Judge, I mean.
Okay, good afternoon, Mr. Meggett. You have count 1, grand theft auto, count 2, operating without a valid DL, bond set at $1,000. On count 1, count 2, your ROR. Any objection to probable cause?
No, Judge.
Okay, the court does find probable cause. Anybody wish to be heard with regard to the $1,000 bond?
Mr. Meggett was placed on pretrial supervision on the 19th of February in case number 17-12604, CF10A, for 1 count of grand theft. Based on this court's finding of probable cause, we're going to ask that his pretrial status be revoked at this time.
Okay, anybody wish to be heard with regard to the $1,000 bond?
Yes, Your Honor. I'm going to be requesting a $5,000 bond in addition to the pending case that the court's aware of. Mr. Meggett, in 2009, was convicted on 2 separate cases, one for robbery with a firearm or deadly weapon and armed kidnapping. He was sentenced to 8 years state prison. Second case in 2009, attempted robbery with a firearm or deadly weapon.
Okay, so when was the one you just mentioned?
They were
What
both
year?
in 2009.
2009.
He was sentenced to 8 years state prison concurrently on each case. He was released from state prison October 12, 2015.
Okay, defense?
Judge, at this time, Mr. Megas advised me he's unemployed at this time. He lives with his mother in Sunrise. Financially, it's going to be hard for anyone to post his monetary bond. I'd ask you at this time just to keep the standard bond in place and on count 1, Judge.
Is he on standard pretrial or GPS on,
I believe standard, Judge.
pardon? Yes, I would like to still check. I'd appreciate it. He doesn't work?
At this time, no, he's looking for work, Judge, but he's not currently working, Judge.
Okay, court's gonna order no victim contact, direct or indirect, with the alleged victim with the initials LJM. That means, sir, no contact in person, calling, texting through third parties, or anything through social media whatsoever. Do you understand?
Yes, ma'am.
Okay, court's gonna put you on GPS level 2, $1,000 bond. In case number 18-3035, CF10A, I understand. Oh, wait, I see. 17, thank you. 12604, CF10A. How do I revoke his pretrial of a standard and put him on GPS level 2, $1,000 bond?
Right where it says bond set right there, you can put 1,000 plus GPS pretrial.
GPS level 2, or I'll let you do it. Okay. Thank you. All right, thank you very much. Good luck to you. Jason Christopher Mutrex.
Mr. Mutrux is approaching.
Okay, Mr. Mutrex, you have count 1, possession of cocaine, count 2, possession of heroin. Both counts have a bond set at $1,000 each for a total of $2,000. Count 3 and 4 are at $100 each, that's possession of drug paraphernalia. And count 5 is attaching a registration, license plate not assigned, $25 bond. Any objection to probable cause?
Your Honor, counts 1 and 2 appear to be residue cases. It's a needle and a crack pipe. the odds are pretty good that ultimately Mr. Mutrux will be charged with the drug paraphernalia charges and not the possession of cocaine or the possession of heroin. I'd ask the court to take that into consideration when deciding what an appropriate bond would be for Mr. Mutrux.
Okay, you agree to probable cause that the syringe and the pipe or field tested positive
I do.
for heroin and cocaine?
I do.
Okay, so the court does find probable cause. So, would you like to be heard with regard to bond, anybody? Mr.
Yes,
Romero?
Judge. Yes, and speaking of Mr. Mutrux, what he's advised me, Judge, is he's going to college at Broward College. He's
God bless you, Willie.
studying technology. He's received the Pell Grant, so fortunately, that's assisting him with his tuition.
I know what it is.
Judge, he's at First Step. He's trying to get help for some of the problems he's facing, Judge. He's 33 years old, been residing here his whole life. I believe he's a Navy veteran. Judge, considering this is a residue case, I'd ask you to release Mr. Mutrux on standard pretrial release.
Does he reside at 6041 Northwest 67th Court?
Northwest Second Street.
No, Judge.
That's my mom's address.
Okay, is that where you get your address? I mean, your mail?
Your mail.
Yes, that's where I get my mail.
Or that's where he can get correspondence, but right now I believe he's residing at First Step Sober House.
Just want to make sure the court is aware of Mr. Mutrux's criminal history.
Sure.
2015, burglary of a dwelling, he violated probation. 2008, grand theft,
Hold on one moment, sir, or mute it, Mr. Romero, please.
2008, grand theft, violation of probation. 2008, burglary of a dwelling, grand theft, possession of burglary tools with a violation of probation. 08, grand theft, resisting a merchant with a violation of probation. Possession of cocaine, 07, violation of probation. Theft, possession of prescription medication without a prescription in 08. Resisting without violence, 07. Theft, 05. DUI, 05.
Okay. What bond can he afford?
Nothing's changed. No bond, Judge.
Okay, counts 1 and 2, the court's gonna set bond at $100 per count. Also for 3 and 4, $100 each, 25 for count 5. GPS level 2 pending verification to a drug rehab facility. What's the name of the one that he said he's at?
First Step Sober House.
First Step, where is that?
Pompano.
You know the address, sir?
450 Southwest Second Street.
Okay, so GPS level 2 pending verification to First Step Sober House or another drug facility. Thank you.
Thanks, Judge.
Nathaniel Cheatham?
Mr. Cheatham is here present, Judge, at Maine.
Okay, Mr. Cheatham, you have 1 count of possession of cocaine, possession of heroin, possession of cannabis. Driving while license is suspended, first offense, and resisting an officer or obstructing, bond set at $1,000, and $3 $100. Total is $2,300. Any objection to probable cause?
No, Your Honor.
Okay, the court finds probable cause. Let's talk about bond.
Your Honor, Mr. Cheatham is currently out on bond for possession of cocaine. 2015, possession of PVP. 2014, possession of PVP with the violation of probation. 2014, possession of PVP with a violation of probation. 2010, felony possession of controlled substance with a violation of probation. Battery, 99, possession of cocaine with intent to sell or distribute with a violation of probation in 98.
Okay,
He also has 4 prior failures to appear.
okay, defense?
Judge, considering what Mr. Lender advised the court at this time, we'd ask you to leave the standard bonds in place. We feel that's reasonable under this circumstance.
Okay, $2,300 bond. Thank you, sir. Good luck to you. Okay, and then next one is Philip Leonard Santoro. Is that a medical reset again?
Yes.
Did you ever find out what's going on?
I haven't. I know that we're in the process of trying to locate him so we can visit him. As the court is aware, BSO keeps the location of somebody who's not actually in the jail pretty well under wraps. I'll check back with Mr. Goldberg later this week or tomorrow. He's out today.
Okay,
But
is
when he
there
comes
anything
back, I'll
that
check.
someone can do in commitment or pretrial to assist the public defender's office to locate his client?
They will tell us, right, they will tell us right before it's time to go visit the person.
Okay,
So it's something that for security reasons, they keep very tightly
I
under wraps.
understand. Thank you.
Judge, we have one last gentleman here at Maine.
Okay.
His name is Norberto Nieves.
Okay, Madam Clerk, Madam
27.
Commitment, and Madam Pretrial. Is everybody here? There's someone here for another case, and I don't have paperwork.
On page 27 of the docket, Judge, it was the gentleman right before Mr. Santoro.
Say, is there paperwork that got attached, maybe? Let me see. Norberto Nieves.
Yes, Judge. Yeah.
Pardon? All right, so let's get the paperwork together. Let's set them for this afternoon, okay?
Yes, Judge.
Thank you. We'll see you back at 1 o'clock, Mr. Nieves. All right, thank you very much. We'll be back at 1. There's a private attorney. We had someone yesterday, Cole Michael Lapointe, and what did they say?
They said that he is being held in custody still due to the fact that he's on a TAD monitor instead of an ELMO. And see what he can do.
Okay, Ms. Patrice, can you tell me Cole Michael Lapointe? Lapointe. Pull him up on sheriff.org. Thank you.
Cole, C-O-L-E.
Cole Michael. We had him yesterday. It was page 2 of the docket. It was touch or strike battery. According to the private attorney's office, he's being held. He says he should be an Elmo, but I understand. But so he said should be an Elmo. Let me call him back and see what's going on. So do you know why he's still being held? Yes, hi Jesse, this is Judge Malika calling from First Appearance Court. You're on speakerphone and being recorded.
Hi, good morning, Judge Malika.
How are you?
I'm well, thanks.
What seems to be the problem with your client, Cole Michael Lapointe?
Yeah, I just wanted to clarify because yesterday I believe you said that he was to have $1,000 on and a tax monitor. Is that accurate?
Yes, it is.
Okay, because what's holding him up at the jail is that they have that he should be on an Elmo. And so he has not been released because they're waiting to fit him for an Elmo and not the tax monitor.
It's,
Okay, but that's not the point. What, I think what she's trying to say is that both of them are electronic monitors. However,
Okay.
why is he being held? Can I ask you that?
I'm sorry?
Okay, but why, did he post $1,000 bond?
Yes, that's been posted. I've already spoken with the bondsman.
So does anybody know why he's still being held since yesterday?
Sheila, I'll get.
Okay, 9:15, hold on, Ms. Patrice. 9:15, his address was verified, and in 9:17, the victim's address was verified. So that's an hour, a half an hour ago. So what's your guess of when he should be released, just so I can tell this attorney? Will he be out by the end of the day, most likely? Okay, so he should be released sometime today, but they have a TAD monitor for him to wear, right? Ms. Patrice?
I see nothing that said there was any delay based on that. It was because of the fact that they didn't know.
Okay, so with the TAD, even though it's only a monitor for the alcohol, they have to verify, and because it's domestic violence, they have to verify and notify the alleged victim in the case. So let me ask you a question for future reference. If you don't get a call back from the alleged victim, then what happens? Does someone just sit in custody, or how much time do you wait, or do you only, are you only required to call in? How does that work? Okay. All right, so, all right, ma'am, so if nothing happens by the end of today, call my office, and we'll call them up for tomorrow morning and see what the issue is, okay?
Okay, thank you so much, Judge.
Thank
I
you.
appreciate it.